Hello and welcome to BQ Prime. You're watching this special interaction with Jane Gupta, who is the managing director at Stakeholders Empowerment Services, which is an investor advisory uh, company. And we are looking at the impact of the Supreme Court panel headed by Justice Sapre. And what kind of impact it could have on markets and regulatory policies going forward. Mr. Gupta, thank you for joining us from London. My first question to you is that you've gone through the report. What is your prima facie, takeaway with respect to what kind of changes that could be needed as a result of that panel's report?
See, I would say the panel's report is rather a fact-finding mission, and they have found all the facts related to the issues that were raised before Supreme Court, and Supreme Court had given 5 points to the committee to find out what is the factual position, and they have given the factual position. Going forward, what happens, it will be anybody's guess, because how the Supreme Court reads that report, what is their opinion, and if you have already seen, there have been some articles that the toothless panel and all that. And if somebody expected that the panel to have a tooth and bite somebody, it would have been extremely wrong, because what was their remit? They have done their work.
Mr. Gupta, if you look at the remit, it was supposed to look at the systemic failure of SEBI, which they have found that there has been no systemic failure because SEBI, because the regulations are in place. But it has also looked at various other policies and current regulatory policies which have been followed, and there may be some scope to improve those policies, and it's up to SEBI to do that. That's what the panel says. For example, we've seen the panel based on the SEBI findings talking about 6 entities which have been probed for short selling. Now, short selling is not available in cash market for us, but in the F&O market, they found that 6 entities have sold prior to the Hindenburg report, and then they squared up after the report was released. How do you think the regulator will look at this kind of trading pattern? I want to get your views on it, because you've been there as part of you were part of the regulator at one point in time. So how does normally a regulator look at that kind of trading pattern?
See, forget my being part of a regulator, because it was almost 11 years back, so many things have changed. Now, coming back to the short selling, as you already said, that in the cash market, short selling is not allowed, maybe except in the intraday, but F&O market is allowed. And it would not have been an issue if there was no report of Hindenburg and that person would have made money. But what happens, because Hindenburg report was released and few days before Hindenburg report, a massive short position was done. If it would be 100 shares or 1,000 shares or maybe 5,000 shares, probably this would not have attracted things. So SEBI probably would be probing that what is the link between those short seller and Hindenburg report, where they privy to Hindenburg report prior to its release, or where they were one of those investors who had approached Hindenburg for issue of report. Because if you see Hindenburg way of operation, either they are approached by shareholders or some investors to issue reports, or they approach investors and they do research and release the report. So if it is established that they were one of those investors, then it would be, because on Hindenburg there cannot be an action, because Hindenburg is not under jurisdiction of SEBI. But Indian investors are certainly under jurisdiction of SEBI, or all those who are registered with SEBI like FPI. So that, let us wait for that probe, but the report has very clearly brought out that apart from those investors, there was nothing found in last 2-3 years as far as the trading pattern in Adani stocks are concerned. So SEBI will certainly, maybe 1 month, 2 months, or 3 months, whatever time it requires, they will come out and we will all know in public domain what was the factual position.
Give us a sense of how this works, Mr. Gupta, because my understanding is that institutional investors cannot go naked short in the futures market unless they are hedging their portfolio. Now, in this case, there are four FPIs which have been identified: one corporate body and one individual. Uh, do you see a violation if the FPIs have gone and shorted the stocks or the market uh, without any portfolio?
I don't think I will put my foot in my mouth without knowing the details. So I will not be able to say whether there is a violation or not violation. SEBI will see what is their trading and what is the law and what was their position and determine what is the violation. If I say violation today, then what is the need for SEBI probe?
No, I get that. What I'm saying is from a from regulatory regime point of view, uh, can FPIs
So
go ahead and do a naked shot on companies and the market without if there is
I,
no portfolio to hedge?
I wouldn't be able to say because I'm not aware of the latest regulation in this regard.
Okay. What could be the kind of investigation that can follow? I'm trying to look from a point of view of whether if there are unlawful gains which have been made as a result of these shorts, is there a way of disgorging these gains back?
So I will tell you. In normal course, if somebody has done a short which is within the framework of law, whatever gains are there, it is his personal gain and subject to taxation in the normal course. But if there is some sort of unfair trade practices found, and if it is found that the person was privy to Hindenburg report and it was part of the investors group who had instituted Hindenburg through the report or whom Hindenburg has already contacted. So then they will have to try to fit in with the law. What is there? SEBI has very wide powers under SEBI Act because ultimately it will. The issue is this: did it impact the market without any reason? And if it is found that yes, that their short selling was one of the reason for impacting the market, probably they will be able to frame them. But exactly what is the violation, it will only be known when we have data and details.
Mhm. Do you see some kind of changes happening in the F&O market, especially for investors like retail? Uh, because currently we've seen a lot of influx of retail investors coming into the market, trading in options. The number of active retail investors have gone up tremendously in the last 2 to 3 years. Do you see some kind of intervention by the regulator to prevent losses to investors in the F&O market, especially, which is very complex as compared to a cash market?
See, I don't think SEBI will ever say that my intention is to limit the losses for retail or anybody. What SEBI will always say that this is the risk and you should be aware of the risk. If SEBI has permitted F&O market, then they cannot shut F&O market. They can only make rules of the exposure, that what should be the exposure limit, who can do something. But if you see, when I watch news channel, it is always there and say the SEBI report says that more than 90% of investors who participate in F&O market lose money. So SEBI is already trying to educate. But if I, although knowing that 99% or 90% plus people are losing money, still I want to stick my head, then nobody can stop it.
Mhm. Mr. Gupta, finally, we saw the impact of the Hindenburg report on the stock prices of Adani companies. There were retail investors who were invested in it, and they've lost money because of the report which has come in. Is there a way SEBI or the regulator can bring in measures to protect them against such kind of events, or is it part
See,
and parcel of the market risk?
see, it is part and parcel of the market risk for the simple reason equity by nature, by name, is prone to risk. However, in this particular case, the risk was enhanced, volatility was enhanced because of one, because of Hindenburg report. Secondly, the support the Hindenburg found from unexpected quarters. And that is where I am very much concerned. Any company can suffer, or any promoter can suffer, if 10 political parties and 10 social groups and hundreds of WhatsApp media can start a campaign against any business house, small or big. That is the problem. And I think Supreme Court must address this. When they are dealing with the petitions of people, they must ask, what is your locus standi in this? How you say this? And because of your noise, this is the loss to the investor. Who is going to compensate them? Are political parties going to compensate? Or all the social media going to compensate? Or all the petitioners who petition to the Supreme Court against this thing are going to do something? And mind you, that whatever Hindenburg has written, almost everything was in public domain, and most of the thing was history. If you are writing something what happened in 2006 and you are not writing full, I still remember one example when I said that Rajesh Adani was arrested in 2006. Yes, he was arrested but released on bail and exonerated by Supreme Court. So you have not written the second and third part. You have written only one. So the aim was to cause panic, and Hindenburg was not wrong because they said that my aim is to make money by this. So they were transparent. But people who got trapped in India and who supported Hindenburg without knowing what Hindenburg's intention or agenda is, they are the people who should introspect and say what loss they have caused to their own constituency. Because Adani investors, Adani employees, Adani consumers, State Bank of India employees, State Bank of India depositors, LIC policyholders, they could be their voters also.
Mr. Gupta, finally, do you see changes coming in because of this? What you said just a while back, who should be responsible for the losses for the investors? Is there a way some regulations can be brought in, some curbs or disclosure standards can be brought in when such reports are brought to the public forum? Can there be some measures be taken so that it doesn't go and it doesn't get repeated with any other promoter group or any other industrial group?
See, as far as the India is concerned, there are enough regulations. When my company releases the report, I have to be abiding by the law. I am abiding by what SEBI says. Everything is based on fact, and there is a warning and disclaimer. Unfortunately, in a situation like this, when Hindenburg issues a report, none of the SEBI laws apply. So that SEBI is unable to take any action against such person. The issue is that not everything cannot be done by regulator. It has to be done by me, you, and everybody. If I am supporting Hindenburg report, I must have a reason and believe that why I am believing that Hindenburg report is true. Just because I don't like a person A or don't like a person B, I cannot malign person A or B.
Mr. Gupta, it was a pleasure talking to you today. Thank you very much for joining us on BQ Prime.